salvage, towage, pilotage, seafarers' wages, masters' disbursements, supply of necessaries, and pollution damage. Such claims may give rise to a maritime lien in certain instances, for example, wages, salvage, and damage, or simply confer a statutory right of action in rem against the offending ship or a sister ship. The Supreme Court in Pacers Multi Dynamics Limited and MV Dancing Sisters, a 2012 decision, confirmed that the supply of bunkers and other necessaries constitute a general maritime claim enforceable in rem under Section 2, Sub 3, Sub R of the AJ. Similarly, in Texaco Overseas Petroleum and Pedman Nigeria Limited, a 2002 decision, pollution damage was recognized as a general maritime claim. Let us now look at proprietary maritime claims. Proprietary maritime claims, on the other hand, are claims that directly concern the title, the ownership, the possession, or mortgage of a vessel itself. These are specifically enumerated in Section 1, Sub 1A to F of the AJ 1991, and include disputes as to ownership or co-ownership of a ship, questions arising between two co-owners regarding possession, employment, or earnings of the ship, mortgage claims, and matters of forfeiture or condemnation. Because they touch the very proprietorship of the vessel, they enjoy the highest priority in the distribution of proceeds from a judicial sale. The Supreme Court in GP Industries Limited and MV Kottamanis, a 2024 decision of the Nigerian Supreme Court, emphatically restated that a ship mortgagee's claim is a proprietary maritime claim under Section 1 Sub 1D of the AJ 1999 and ranks above all general maritime claims when sale proceeds are distributed. Earlier, the Court of Appeal in Nigerian Ports Authority and P&I Associates Limited held that disputes over ownership fall squarely within the proprietary category and can only be determined by the Federal High Court. The possessory action in MV Marina and Owoseni in 1999 decision was likewise classified as proprietary. The practical consequences of this classification are far-reaching. In the hierarchy of claims upon judicial sale of a vessel, proprietary claims rank first, followed by maritime liens arising from general claims such as wages and salvage, then other general maritime claims, and finally, ordinary unsecured claims. A vessel arrested for a general maritime claim cannot subsequently be arrested by a proprietary claimant unless the earlier arrest is released, a principle derived from once arrested rule. Limitation periods also differ. Many general maritime claims under the Merchant Shipping Act are subject to 2-year limitation, whereas proprietary maritime claims generally attract the 6-year period under the Limitation Act. In essence, the distinction between general and proprietary maritime claims under the Admiralty Jurisdiction Act is not merely theoretical. It determines priority of payment, the availability and sequence of arrest, and the applicable procedural regime. Nigerian courts, from early decisions in MV Marina and Owoseni to the recent authoritative pronouncements in Pesas Multidynamics and GP Industries and MV Kotamanis, have consistently applied and refined this clarification to ensure predictability, fairness, and commercial efficiency in the resolution of maritime disputes. Maritime claims in Nigeria may be enforced through distinct modes of actions. Maritime claims in Nigeria may be enforced through 2 distinct modes of action: an action in personam against the person or entity personally liable, or an action in rem directly against the ship or sister ship itself. This dual remedy is a hallmark of Admiralty jurisdiction worldwide and is expressly recognized and regulated in Nigeria by the AJ in 1991. The statutory basis for the dual procedure is found in Section 5 AJ 1991. Section 5 sub 1 provides that any maritime claim enumerated in sections 1 or 2 AJ may be brought either as an action in personam against the owner, charterer, manager, or operator of the vessel, or as an action in rem against the offending ship or any sister ship owned by the person who was the owner of the demised charterer at the time the cause of action arose. Section 5 sub 3 further authorizes the arrest of the vessel to found or confirm jurisdiction and to provide security for the claim. This statutory framework reflects the practical realities of international shipping, where ship owners are often foreign and transient, making the vessel itself the most reliable source of satisfaction for maritime claimants. An action in personam is the conventional civil suit directed at individual or corporate entity responsible for the death or damage. It follows the ordinary rules of service and jurisdiction requiring personal service of the writ within Nigeria or leave of court for service outside jurisdiction. While straightforward in principle, an action in personam action is often ineffective against ship owners who have no presence or assets in Nigeria and who refuse to submit to the court's jurisdiction. An action in rem, by contrast, treats the ship as the defendant. The proceedings are commenced by the issuance of a writ in rem and the arrest of the vessel, with the writ being served by affixing it to the mast or another conspicuous part of the ship. The arrest compels the real security for the release of the vessel. The Supreme Court has described the action in rem as a unique procedural device designed to secure the presence of the owner and to create a fund from which the claimant might ultimately be paid. In Pacers Multi-Dynamics Limited and MV Dancing Sisters, a 2012 decision, the court emphasized that the action in rem is not against the ship as a physical object, but a legal fiction that brings the owner into jurisdiction and provides tangible security. Nigerian courts have consistently affirmed the absolute right of the claimant to elect between the two forms of actions. In MV Ship and MVS Aras, a 2000 decision of the Nigerian Supreme Court, the court held that once a claimant properly constitutes either an action in personam or in rem, the court has no power to compel conversion from one form to the other. The Court of Appeal in Pillar Enterprises Limited and MV Saldanha, a 2007 decision, clarified that liability in rem is determined by ownership at the time of the cause of action arose, not at the time of arrest. More recently, in GP Industries Limited and MV Kota Menis, the Supreme Court reiterated that the action in rem remains a cornerstone of Admiralty procedure, distinct from ordinary civil actions and governed exclusively by Admiralty rules. In practice, most maritime claims in Nigeria, whether for cargo damage, collision, salvage, unpaid bunkers, or crew wages, are commenced as actions in rem because the arrest of the vessel provides immediate and effective security. Under Order 5 of the AJPR 2023, the AJPR allows arrest on a prima facie showing of a valid maritime claim without the need to prove the full merits at the arrest stage. The coexistence of actions in personam and in rem under Section 5 AJA 1991 as repeatedly endorsed and applied in cases from MV Ship and MVS Aras to GP Industries and MV Kotamines continue to afford maritime claimants in Nigeria a powerful, flexible, and commercially effective means of enforcing their rights. Limitation periods for making maritime claims in Nigeria. The limitation period for maritime actions in Nigeria are not uniform but depend on the nature of the claim and the applicable statute. Nigerian law draws time bars from a combination of domestic legislation and international conventions that have been domesticated, principally the AJA 1991, the MSA 2007, and COGSA 2004, the Hamburg Rules 2005, and where no specific maritime period exists, the general limitation laws of the various states. Claims arising from the carriage of goods by sea remain the most frequently litigated. For outward shipments, the Hague Rules, incorporated through the Carriage of Goods by Sea Act, Cap C2, Laws of the Federation 2004, impose a one-year limitation period running from the date of delivery or the date when the goods should have been delivered. Hence, since Nigeria domesticated the Hamburg Rules 1978 by enacting the United Nations Convention on the Carriage of Goods by Sea, Hamburg Rules Act 2005, the prevailing position for both inward and outward carriage is a 2-year period calculated from the same trigger dates. The Court of Appeal has repeatedly affirmed the supremacy of the Hamburg Rules in this context, notably in the owners of cargo of MV Stella Maris and NPA, a 2003 decision, and more recently in MSC Mediterranean Shipping Company and Oando PLC, a 2022 decision, thereby extending the limitation period to 2 years in the majority of international cargo claims involving Nigeria. Collision claims and claims for salvage reward are governed by the MSA 2007, Section 357 expressly stipulates that an action for damage done by ship must be commenced within 2 years from the date the damage or injury was caused, and Section 404 MSA applies the same 2-year period to salvage reward claims. The Supreme Court enforced this position strictly in the Nordic Spirit and the Nigerian Ports Authority, refusing to extend time even on grounds of force majeure and emphasizing that the period is mandatory. Seafarers' wages claims and most claims for personal injury or loss of life caused by a ship are likewise subject to a 2-year limitation under the MSA. Oil pollution damage claims governed by the regime of the 1992 Civil Liability Convention incorporated in Part 17 of the MSA must be brought within 3 years of the date when the damage occurred, subject to an outer absolute limit of 6 years from the date of the incident. Proprietary maritime claims such as dispute over ship ownership, co-ownership, possession, or enforcement of a ship mortgage, fall outside any special maritime limitation regime. They are therefore governed by the ordinary limitation statutes applicable in the states where the action is filed. In most states, this means a 12-year period for recovery of actions found on contract or tort. The Supreme Court implicitly endorsed this approach in GP Industries Limited and MV Cotter-Menis when it treated the mortgage proprietary claim as subject to general limitation law rather than any maritime specific bar. Claims for towage, pilotage, general average, and in the supply of necessaries such as bunkers or provisions have no dedicated statutory time bar in Nigerian maritime litigation or legislation. They accordingly attract the ordinary 6-year limitation period applicable to actions founded on simple contract. This position was upheld by the Supreme Court in Pesas Multi-Dynamics Limited and MV Dancing Sisters, where a bunker supply claim commenced within 6 years was held competent. A notable short period applies where a ship owner seeks to limit liability under the 1996 LLMC Convention as amended, or the term Rule 8 of the AJPR 2023 requires the limitation action to be instituted within 60 days of the receiving written notice of a claim, failing which the right to limit may be lost. Nigerian courts apply these limitation periods with rigor and rarely exercise discretion to exercise time. From the Supreme Court decisions in the Nordic Spirit and Pesas Multi-Dynamics to the consistent Court of Appeal jurisprudence on cargo claims, the message is clear and direct. Maritime claimants must act with expedition once a cause of action crystallizes, as time bars in this specialized jurisdiction are enforced strictly and without exceptions. Now, we move to foreign jurisdiction clauses in maritime contracts. Section 20 AJA represents a cornerstone of maritime legal framework in Nigeria, mandating that any agreement seeking to house the exclusive Admiralty jurisdiction of the Federal High Court shall be null and void if the matter relates to Admiralty claims and has a Nigerian nexus, such as performance, residence of parties, or payment occurring in Nigeria. This provision embodies a deliberate policy of jurisdictional protectionism, ensuring that maritime disputes with local connections remain within Nigerian courts to safeguard economic interests and prevent forum shopping. Nigerian courts, particularly the Supreme Court, have grappled with its interpretation, especially concerning foreign jurisdiction clauses in bills of lading, charter parties, and arbitration agreements. While the Supreme Court has generally upheld the mandatory nature of Section 20AJ, removing judicial discretion in favor of automatic nullification, there have been instances of misapplication, often at lower courts or in early decisions that overlooked the provision or conflated it with arbitration laws. This discussion examines key cases where Section 20 of the AJ was rightly applied, reinforcing its protective intent, and those where it misapplied, leading to inconsistent outcomes that have been critiqued or overruled. The foundational case rightly applying Section 20 AJ is the Sona Nigeria Limited and the Nordwing, a 1987 decision. This decision is a pre-AJA decision that profoundly influenced its interpretation. Although rendered before the enactment of the Admiralty Jurisdiction Act, the Supreme Court, through our very own Oputa JSC, refused to stay proceedings in a cargo claim under a bill of lading with an English jurisdiction clause, upholding that such clauses are unenforceable if they oust Nigerian jurisdiction in matters with local nexus. The Supreme Court emphasized public policy against forum shopping, stating that the ends of justice demand that the Nigerian plaintiff should not be driven from the doors of Nigerian courts. Beautiful logic. This decision laid the groundwork for Section 20 AJA, treating foreign clauses as void ab initio in Admiralty matters, and has been cited as the policy progenitor in subsequent cases. Building directly on this, in JFS Investment Limited and Brow Line Limited, a 2003 decision of the Nigerian Supreme Court exemplifies a correct application by the Nigerian Supreme Court. In a dispute over a charter party with a foreign arbitration clause, the Supreme Court, through the famous Ogundare JSC, took judicial notice of Section 28J and held it virtually eliminates judicial discretion, rendering the clause null and void due to the Nigerian connection. Performance and payment was in Nigeria. The court affirmed the Federal High Court exclusive jurisdiction as provided for under Section 251 sub 1 sub G of the Constitution of the Federal Republic of Nigeria 1999, reinforcing that Admiralty claims cannot be diverted abroad. This decision clarified that Section 20 AJ applies strictly to ouster agreements, prioritizing national sovereignty over party autonomy. Another landmark right application is in the owners of NV Lupex and the Nigerian Overseas Chartering and Shipping Limited, a 2003 decision where the Supreme Court, per WIFO JSC, distinguished Sona but still invoked the principles of Section 20AJ. Despite granting a stay for foreign arbitration under the Arbitration and Conciliation Act, Cap 18, Laws of the Federation 2004 now repealed, the Supreme Court noted that the clauses limited ouster effect and Nigerian nexus, ultimately holding the Federal High Court's primacy. However, latest critiques highlighted that the court did not fully engage Section 20, but its net effect was to limit enforcement of foreign clauses aligning with the section's intent. The decision of the Supreme Court in MVS Anani and the owners of MVS Anani, a 2014 decision, further solidifies correct application. In a collision claim with the Foreign Jurisdiction Clause, the court, per Rhodes Vivor JSC, declared the clause void under Section 28J, emphasizing that it seeks to house the jurisdiction of the Federal High Court in a matter squarely within its Admiralty purview. The ruling stressed the role of Section 28J in protecting Nigerian interests, refusing a stay, and allowing the action to proceed in rem. More recently, Ladrop Limited and MV CSC Australia, a 2020 decision, and Zenith Global Freight Limited and MV Nordems, a 2022 decision of the Supreme Court, represent the authoritative restatement of the Supreme Court. In that group, the court, per Cas JSC, invalidated an English exclusive jurisdiction clause in a bill of lading for cargo damage in Nigerian waters. Holding Section 28J renders such agreements null and void to that extent, without discretion. Similarly, in Zenith Global Freight, Okoro JSC describes Section 20 as a deliberate legislative intervention to protect Nigeria's maritime jurisdiction and prevent capital flight, voiding a foreign clause in a charter party dispute. These cases underscore the non-negotiable application of Section 28J in Admiralty matters within Nigerian links, influencing even non-maritime matters, non-maritime courts to differ. At the Court of Appeal level, correct applications abound, such as MV Panamos Bay and Olam Nigeria PLC, and Lignins Arends Congolese and Air Atlantic Nigeria Limited, a 2008 decision. In Panamos Bay, the court refused a stay for a foreign arbitration clause in a maritime claim, holding it an impermissible ouster under Section 28J, which motivates Section 4 and 5. In Lignins Ariens, the court echoed this, voiding a clause in an aviation-related Admiralty matter due to Nigerian performance, affirming the exclusivity of the Federal High Court. Unfortunately, or contrastingly, misapplications of Section 20 have often stemmed from judicial reluctance to prioritize Admiralty over arbitration, or from overlooking the provisions entirely, leading to enforcement of foreign clauses and stays that undermines the Federal High Court's jurisdiction. The most notorious of these is the decision in the owners of MV Lupex and the Nigerian Overseas Chartering and Shipping Limited, where the Supreme Court, while distinguishing SONA, granted a stay for foreign arbitration without directly addressing the implications of Section 28J, while for JSC critiqued the Section 20 as working on its head and poorly drafted, applying the ACA discretion instead. This was widely seen as a misapplication, as it allowed ouster in a charter party with Nigerian nexus, contradicting Section 28J's mandatory nullification. Subsequent scholarship and courts have critiqued this decision for ignoring the supremacy of the AJ in Admiralty. A lower court misapplication occurred in Fugro Subsea LLC and Petrolog Limited, an unreported decision of the Court of Appeal in the 2020s, where the Court of Appeal held that arbitration clauses do not house the Federal High Court jurisdiction but merely suspend it, granting a stay despite Section 28J. The decision conflated arbitration with jurisdiction clauses, treating the former as enforceable under the new Arbitration and Mediation Act 2023, which states, notwithstanding any law, critics argue this misreads Section 28J as it renders ouster agreements void regardless of suspension, potentially harming the maritime attractiveness of Nigeria by encouraging forum shopping. Early post-AJA confusion is evident in Onward Enterprises Limited and MV Matrix number 2, a 2010 decision where the Federal High Court initially enforced a foreign clause without invoking Section 20, only for it to be reserved on appeal. The trial court's oversight exemplified misapplication by failing to recognize the section's automatic effect. Similarly, in MV Arabella and the Nigerian Agricultural Insurance Corporation, a 2008 decision, while primarily on Admiralty and maritime law, tangential discussions on clauses ignored Section 28JA, leading to inconsistent stays in related disputes. These misapplications highlight tensions between Admiralty protectionism and pro-arbitration policies under the ACA and AMA. However, the Supreme Court interventions in JS investment, in MV As and Air and Zenith Global Freight have largely corrected the course, establishing that Section 28J trumps discretion in Admiralty matters. Lower courts errors, like in Fugro, persist but are vulnerable to reversal, underscoring the need for legislative clarity, perhaps via AMA amendments to resolve arbitration overlaps. It is important to note that while rightly applied cases like Sona, JFS Investment, and Zenith Global Freight affirm Section 20's role in bolstering Nigeria's maritime sovereignty, misapplications such as MV Lupex and Fugro reveal interpretative pitfalls that erode predictability. As the blue economy expands in Nigeria, appellate fidelity to the protective stance of the Supreme Court will be crucial, ensuring Section 20 AJ serves as a shield rather than a source of uncertainty. Maritime practitioners must thus plead the section robustly to invoke its nullifying power, aligning judicial outcomes with legislative intent. In conclusion, the maritime claims regime in Nigeria remains a robust and claimant-friendly framework anchored in the enduring coexistence of actions in rem and in personam under Section 5 of the AJ in 1991, as consistently upheld by the Supreme Court from NV Ship and MVS Araz to GP Industries and MV Kota Menis, and reinforced by the streamlined arrest procedure in Order 5 AJPR 2023, which demands only a prima facie maritime claim for the immediate and effective security provided by vessel arrest. Yet, this powerful enforcement mechanism is tempered by the rigorous and inflexible application of limitation periods, with the Supreme Court and the Court of Appeal authorities from the Nordic spirit and Pesas multi-dynamics to cargo claim precedents, underscoring that time bars are enforced strictly and without exception, compelling claimants to act with expedition. Meanwhile, while Section 20 AJ rightly fortifies the maritime sovereignty of Nigeria when correctly applied, as affirmed in Sona, JFS Investment, and Zenith Global Freight, misinterpretations in cases such as MV Lupex and Fugro highlight the need for appellate fidelity to the protective stance of the Nigerian Supreme Court. As blue economy expands in Nigeria, sustained judicial consistency and robust pleading of these provisions will ensure that the AJ continues to serve as both an effective shield for national maritime interests and a predictable, commercially viable tool for the enforcement of maritime claims. Ladies and gentlemen, thank you for listening to us. You may have stumbled on this video, or perhaps you would have subscribed to our YouTube channel. If you've not, we plead with you to please subscribe to our channel and then follow us on other social media handles on Facebook, on Twitter, X, Instagram, and TikTok. Please feel free to share this video with friends, colleagues, and comment, like, and tell us how you feel about what we are doing. We look forward to hearing from you.
The show that shines the light.